Hi there, I'm Christine Van Geyn, the Litigation Director with the Canadian legal charity, the Canadian Constitution Foundation. Today I want to give you an update about a new case that we're announcing. We've announced that we are launching a legal challenge to the federal government's invocation of the Emergencies Act, and this challenge will be by way of urgent application for judicial review at the federal court. The Prime Minister has set a dangerous precedent by invoking the never-before-used Federal Emergencies Act to address the current situation. The high threshold for declaring a public order emergency under the Emergencies Act has not been met. The Act has been invoked to address a failure to use existing legal tools under the Criminal Code, which were used effectively on the Ambassador Bridge. The federal government has invoked the Emergencies Act as a matter of political convenience. This is illegal and it violates the rule of law, and that's why we're challenging this government in court. The Federal Emergencies Act was enacted to replace the discredited War Measures Act, which was used during the Second World War to intern Japanese Canadians and Italian Canadians, and during the FLQ crisis in Quebec. The Emergencies Act is drafted carefully and narrowly to ensure that the federal government can't abuse emergency powers ever again. The Act defines a national emergency as an urgent and critical situation of a temporary nature that A, seriously endangers the lives, health, or safety of Canadians in such proportions or nature as to exceed the capacity or authority of the province to deal with it, or B, seriously threatens the ability of the Government of Canada to preserve the sovereignty, security, and territorial integrity of Canada. It also requires that the federal government demonstrate that the situation cannot be dealt with effectively under any other law of Canada. Emergency legislation should not be normalized. The threshold for using the Emergency Act is extremely high and has not been met. The decision to invoke the Emergencies Act, which has never been used or interpreted by the courts, is unprecedented. If Parliament authorizes the proclamation of a public order emergency, the courts will be the last defense for the rule of law. This isn't about the convoy versus the City of Ottawa. This is about the rule of law. And that's why we are headed to court. If you're interested in following this case, you can subscribe to our email updates at the ccf.ca/freedomupdates. If you're interested in supporting our case, you can make a tax-deductible charitable donation at the ccf.ca. Thanks so much for watching.